Support comes from the St. Louis Public Library Foundation. During these challenging times, free access to digital resources is a necessity. You can help our community stay connected. Support your St. Louis Public Library at slpl.org.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. The city of St. Louis is suing the state to block its takeover of city police. Two different former St. Louis Public Schools superintendents are suing the district, and each is also suing various people for defamation. And the local influencer, known as the Woke Ginger, is suing a nonprofit that seeks to feed the hungry. He says they terminated him to keep a donor happy. Lots of lawsuits and only 1 hour to discuss them. Yes, today is our Legal Roundtable, and we have a great panel to share their insight with us today. And that includes Jenny Woulfe, who is making her Legal Roundtable debut today. Jenny is an attorney with the Clayton law firm Galloway, Johnson, Tompkins, Burr & Smith. She focuses on automobile liability, highway design, premises liability, product liability, and insurance law. She also currently serves as the president of the Lawyers Association of St. Louis. Jenny, welcome.
Thanks for having me. I'm excited.
I'm excited that you're here. We've been trying to do this for a while now, and here you are. We're also joined today by Arindam. He's a shareholder at Polsinelli, and he's chair of the firm's National Antitrust Practice Group, focusing on compliance, counseling, government investigations, and mergers and acquisitions. Arindam, welcome back.
Thank you very much. Good to be back.
And last but never least, today we're joined by Dave Roland, who has a new title for us. He is the Senior Legal Advisor for the Freedom Center of Missouri. Dave, welcome.
Thank you so much, Sarah.
So the city of St. Louis filed suit this month against the state-appointed Board of Police Commissioners and also the state of Missouri. Mayor Kara Spencer alleged that the law giving control of city police to a board appointed by the governor is unconstitutional, and her suit relies on the Hancock Amendment. The idea behind the Hancock Amendment is that the state can't force local governments to spend money without itself providing the money. Doing so would be a, quote, unfunded mandate. And Missouri's prohibition on them has been used to strike down many a law. Dave, a lot of us have been reading about how the state seems to be forcing the city to spend more money on its police department. So does the city have a good case under this Hancock Amendment?
I would say under normal circumstances, yes, they would have a good case because this bill not only changes the amount of money that the city is required to spend, it also changes the way that the amount is calculated. And that's really usually a critical question. The big challenge that I see with this lawsuit, the hill that it has to climb, is that a couple years ago, Missourians amended the Hancock Amendment to expressly authorize the state legislature to increase minimum funding for a police force established by a state board of police commissioners.
Ooh.
Now, at the time, only Kansas City's police board qualified, but because control over the police department in St. Louis has been transferred back, historically, the St. Louis Police Department was established by a state-controlled board, and therefore I think that this is likely going to be a loss for the city of St. Louis here.
Well, Arindam, do you share that analysis?
I do. I agree with what Dave said on the challenge. I think the other issue here is a matter of standing, which, again, as the city of St. Louis, I think historically you will see successful Hancock cases being brought by a taxpayer and not and here with the municipality bringing the case as the plaintiff, I think there are a number of ways that a court could get this case kicked out.
So didn't they get their own budget director, who's a resident, to stand in for the taxpayers? Isn't that sort of a way around the standing argument?
One. I think that's definitely what they're trying to do. I think that was the challenge that you had in the earlier federal case that was brought on. So we'll see what happens. Courts, if they can address things procedurally before getting into the merits, I think those are things that are going to be hurdles that they're going to have to overcome.
Okay. So, Jenny, this seems very grim for city taxpayers who've been counting on this as a Hail Mary. Are we dead in the water here?
I have to agree with both Arindam and Dave here. The issue of that amendment to the Hancock Amendment a few years ago, fortunately is specifically directed at the time. Even the ballot language was just saying Kansas City. But they're trying to plead around this in both the mayor's lawsuit and the Board of Aldermen president lawsuit. But if you look at the statute, when the city took back over the police board, it was transferring the police force that was previously established under the State Board of Police back in Civil War era. So I think a court can reach back to that and say this force was originally established under the state board.
Okay, so they would then qualify for this giant exception that was later added to the Hancock Amendment.
As long as, and they're right on time because this exception expires at the end of this year. But they got the statute out on time.
Man, Dave, this again, is the city dead in the water here?
So after all three of us have poured cold water on the hopes and dreams of the city government here, I do want to throw a lifeline. So, and it goes to the ballot language that was used on this amendment. There have been cases in the last 10, 15 years where the Missouri Supreme Court has put a lot of emphasis on the ballot language that was used as opposed to the text that was added to the Constitution. And so it is at least theoretically possible that the Supreme Court could say, well, even though the language of the amendment itself does not focus on Kansas City specifically, because the ballot language was focused in that direction, voters may have only considered that it was ever going to affect Kansas City, and therefore we're going to interpret this amendment as being limited to that effect. Now, I don't think that that's likely, but it's at least theoretically possible. So there might be a puncher's chance.
A puncher's chance. Ugh, I don't know about a puncher's chance. So as Jenny alluded to, this is one of two different lawsuits that is challenging this state takeover of police. There was one that Mayor Tashara Jones filed. I think it was her literal last day in office. But Aldermanic President Megan Green was also a part of this lawsuit. Kara Spencer later said, I don't want to be a part of this. But it has continued under the auspices of the Aldermanic President. Arindam, this one is actually headed for trial next month. Now, I know, because anytime I say something's headed for trial next month, it gets delayed. We don't know if it's actually going to trial next month. Do these two lawsuits have impact on each other? What if something happens in this other lawsuit, does this solve the problem?
Perhaps, which is a great lawyerly answer, right?
It sure is.
It depends. That's another good one.
You guys love that.
Yeah, the state case, which is going to trial, as we mentioned, the federal case was dismissed. I see some, I think some benefits to this case that are very distinct from the challenges that the city lawsuit's bringing. And so I think if successful, if this case does go to trial, there could be some ramifications from this case that absolutely could be beneficial to the state case if successful. And I'm going to lean on my colleagues to explain why that is.
Is anyone up for this challenge here? Dave?
Okay, so the reason why I think that there is a very strong prospect for the challenge in this other case is that when this bill was passed, the title of the bill said that it was relating to public safety. And there is a provision of the Missouri Constitution that says when the legislature is passing a bill, it must have a clear title. Now, in 2024, the Missouri Supreme Court was considering another case dealing with the city of St. Louis, and they said, in reference to the clear title requirement, of course, we have long held that titles like relating to public safety are too broad and amorphous to satisfy the clear title requirement. Now, in that case, however, the city had not included a clear title claim. Basically, the court said this, chastising them for not bringing a claim that would have been a winner. But that statement that the court made is what attorneys call dicta. It was not actually part of the holding. It wasn't necessary to conclude the case. So it was really speculation. And so the case that is going to trial next week raises the question directly. All right, here's the clear title challenge. Is relating to public safety too broad and amorphous to fairly apprise citizens and legislators of the contents of this bill. I've got a very similar case, raises exactly the same issue, and so I'm pretty persuaded that this should be a winning argument if, in fact, the Missouri Supreme Court meant what it said in 2024. We will find out whether they did.
So 2024 wasn't that long ago. How can they dance away from their own words? Don't they have to mean what they said just 2 years ago? Or do you guys have a lawyerly argument for that too?
It's just dicta. It wasn't a holding of the case,
So
and that gives them
different.
some flexibility.
Oh, boy. Jenny, what do you think about this?
Yeah, that's the scary part about dicta. And even if it was precedent, the Missouri Supreme Court could overturn themselves, although in 2 years would be pretty impressive. But one of the things that I think will be argued here is that a lot of these statutes, we have the clear title requirement, but it's interpreted fairly broadly a lot of the time. And it's going to be argued to them, you invalidate this, you run the risk of a challenge to a lot of these bills that if you go back, because they really, the titles really do tend to encompass a broad number of topics shoved under one bill. So they'll kind of be getting that public policy type argument, and we'll see what they do with it.
Boy, so it sounds like this case, this could be huge. This could all come down to the title, and it could dramatically change the city's finances for the next 10 years, 20 years. I mean, this seems crazy. And it sounds like what I'm hearing from you guys is this could go either way.
Yes.
Yeah, like was said earlier, it depends.
It depends. This does not instill a lot of trust in the rule of law here. But Arindam, we should note the city did get some good news in a different lawsuit involving the state. This one focused on the question of who gets to appoint the sheriff in the matter of a vacancy. The state had previously won the fact that they get to appoint circuit attorneys when we need a new circuit attorney. So what happened here in the case involving sheriffs?
Yeah, this is one of those times where this discussion of local control and what we can really dictate comes to play here. And you're right. Previous decisions as it relates to obviously the circuit attorney in the city where we had this issue went the other way. But on this one, the court did rule that no, looking at the case, looking at the history, that this was absolutely something that is within the purview of the city. This is a local decision, albeit with, I think, and correct me if I'm wrong, meaningful input from the comptroller and the Board of Aldermen president to select the next St. Louis City Sheriff. So. Listen, maybe this will force them to work well together.
Jenny?
Yeah, I think I read Judge McCarthy's opinion, and I thought it was well-reasoned, especially with respect to the decision between the city and the state. I think the statutes are pretty clear here. Unlike with the circuit attorney, what we were dealing with, there's specific statute that says that now here's where it gets dicey, that the county commission gets to appoint if there's a sheriff vacancy. The problem with the city is that the city is not a county. There is statutes, and Judge McCarthy's opinion cites to them, where in most matters when it's talking about a county, the city does qualify for that, but then the question becomes, and that's where we get this meaningful input language, is what is the county commission?
Yeah.
And there's some statutes touching on that, but they're not crystal clear, and that's why we still have this question. I think hopefully the comptroller, the Board of Aldermen, and the mayor can just get together and figure that out so we, take the win that it's staying at least a local decision, but we'll see what happens there.
Yeah, I can't believe your optimism here. I mean, this seems crazy that you have the actual language is, quote, meaningfully include. So this doesn't seem like a legal term here, and you have two parties that were already at odds, the Board of Aldermen and the mayor. I can see this ending right back up in front of a judge. Is the question now before a judge saying what is meaningful and why can I not say this phrase? Meaningfully include?
I think that is, in fact, the question that the court's going to have to sort out. And I think the judge may be hoping that these sides will figure out how to play nice and they'll get it resolved so that they don't have to explore this further.
Like Jenny said, take the win. The state is out of your sandbox.
Right.
Like, play together nicely.
But I think the really interesting thing is in federal court, this is the kind of thing that would be called inherently a political question. Mm-hmm. And the courts would bail on that, and they'd say, you guys have got to sort this out on your own.
Wow.
But I don't think that they have that option here. I think that they're gonna have to sort out who ultimately gets to make this call from among these entities.
All I can say as a city resident, I have not read about the sheriff in the newspaper, the current sheriff, the interim sheriff,
Yes.
for quite some time. So I'm just saying, hopefully they can figure this out.
It does feel like we're now in a much better situation vis-a-vis the sheriff. Maybe we could just maintain the status quo here.
Right.
John Hayden, good man.
Yeah.
Who cares what the judges say? I should never even joke about that. Sorry, guys.
All good.
We're talking to our legal roundtable today. We have a bunch of topics that we're digging into. We'd like to invite you to join this conversation. If you have a question for our panel or some legal analysis of your own, you can call us at 314-382-8255. That's 314-382-TALK. And our panel today includes Arindam Carr of Polsinelli. We're also joined by Dave Roland of the Missouri Freedom Center and Jenny Woulfe, who's with the law firm Galloway, Johnson, Tompkins, Burr, and Smith. We need to take a quick break, but we'll be back shortly to continue this conversation and dig into two lawsuits filed by two former school superintendents. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Gemma, architects, planners, and designers seeking to bring joy to their clients and communities. Details at gemastl.com.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our monthly legal roundtable. Every month we convene some of the top lawyers working in St. Louis to share their insight, help us understand what we're reading in the news. Today that includes Dave Roland. He's a senior legal advisor for the Freedom Center of Missouri. We're also joined by Arindam Carr. He's a shareholder at Polsinelli, also chair of the firm's National Antitrust Practice Group, focusing on compliance, counseling, government investigations, and mergers and acquisitions. And today, making her legal roundtable debut is Jenny Woulfe. She's an attorney in Clayton with the law firm Galloway, Johnson, Tompkins, Burr, and Smith. She focuses on automobile liability, highway design, premises liability, product liability, and insurance law. So, Jenny, last month, our panel discussed the news that one previous superintendent of the St. Louis Public Schools, this is Millicent Borachade, had sued over her termination. Now you can make that two former superintendents. Keisha Scarlett, who was filed by the board even earlier, making way for Borachade's hire, she's now also suing. Keisha Scarlett argues that the district terminated her contract to, quote, deflect its own shortcomings on her and for reporting, quote, illegal activity within the district. She's also suing one of the board members for defamation. I think from the outside looking in, this superintendent was reviled in the media. The big question from the pundits is why it took so long to fire her. Was the conventional wisdom wrong? Does she actually have a decent case that she shouldn't have been terminated?
Well, for her, which is different than what's alleged in the Borachade suit, is that she's alleging a breach of contract. And a lot of times, even if you're doing a terrible job, if they don't terminate you consistent with the terms of the contract, they have a problem. And so she's alleged a whole slew of things in her petition about how they breached the contract. And the question is going to become whether that's true. And we'll have to see how those facts play out.
With a breach of contract type claim, let's say that it's written in very plain English, none of this legalese that all the lawyers like, where it's like, you have to pay this person for 3 years, whether or not they do the job. And it turns out they didn't pay her for 3 years. is it very likely you're going to have to make up that amount of money? You can't just skate on something, even if the person is doing a terrible job.
If they have a straight liquidated damages provision like that, then yeah, you're going to pay that. If she's just alleging, breach of what she should have gained under the contract, which is the payment for 3 years, she does have a duty to mitigate her damages. So the argument becomes then, what she could or should have done to get income in another manner, and that goes to her damages. And then, of course, with the defamation and everything outside of that, she's going to allege harm to reputation and everything like that.
Yeah, it all depends, I guess, on all the terms of this contract. But I don't know, this is not necessarily a case that's dead in the water. Dave?
Well, I'd like to address the defamation claim because I frequently get called by people who are in the public eye wanting to bring lawsuits about somebody having said something else about them that they don't like. And the fact of the matter is if you have a position of public employment, especially one that is high profile, it is almost a guarantee that you will not prevail in a defamation lawsuit because the standard is so high. You have to be able to prove actual malice. In other words, not just they got some facts wrong, not just that these other people who said these things don't like you. You have to be able to show that they actually were intentionally trying to injure you by saying something that they knew was not true. And that is an incredibly difficult standard to reach. And so I frequently tell public figures, it's not even really worth bringing this lawsuit. It's a waste of everyone's time.
Does it help if she has some other facets of this lawsuit? She's just kind of chucking it in there because let's just, throw everything into the kitchen sink.
In theory, it could help, but really a defamation charge like this, I think, should be tossed out pretty early. Like that count maybe should be dismissed so it's no longer on the table when these other issues come up. But it could be seen as a bargaining chip of some sorts. So I don't know. That might be why some of these defamation claims get tacked on to others. But really, the standalone defamation claims are the ones that are generally just unworkable and very unlikely to succeed.
Jenny?
Yeah, I agree about the bargaining chip part because the defamation is specifically against Matt Davis. So you have an individual here, and that a lot of times makes a difference in suits like this because the individual is a lot more concerned about, their personal liability, their personal finances, where you have a school district, an entity. It's a different story.
That makes sense. Arindam?
Although I would add, and again, I haven't looked at it at this level, but I would assume Mr. Davis would have some sort of director, officer, insurance liability protection being a board member. So it may be just another bucket of money that, again, they're trying to seek some remedies for.
Yeah. So I'm looking at these two lawsuits and I'm wondering, can anyone file a lawsuit? It seems like these, again, in the court of public opinion, those of us on the outside looking in, everyone kept saying these superintendents need to go. The board got rid of them. And now here, the board is probably going to be facing a fat legal bill. Dave, is it anybody can sue?
Literally anybody can sue. The question is whether their suit will actually get to a trial or a definitive resolution on the merits. Frequently, if a suit is very weak, like if the facts just are bad or if you don't have the law on your side, then these will be disposed of relatively quickly via a motion to dismiss or a motion for judgment on the pleadings. So there are ways of kind of weeding out the frivolous lawsuits. But literally anybody can bring a lawsuit. There's just no guarantee that it's going to be successful.
Do any of you feel strongly that one of these lawsuits seems a lot stronger than the other? Or are these things we're both just going to have to see how they play out?
I mean, I think as Jenny mentioned, the breach of contract case, there's some potential teeth there.
Okay.
Again, we'll see what happens, but versus the other case, that's probably the strongest piece here, right? We've talked about the defamation claim. I think both cases have whistleblower claims. I think Scarlett's whistleblower case, again, is at least in the pleadings a little more defined as to what she was whistleblowing about, whether it was actually a surprise that there were unpaid invoices and things. I don't know.
Misspending.
Yeah, I don't think there was
shocking.
any blowing of whistles on that. I think we knew that, but we'll see. We'll see.
Jenny, am I remembering this right, that you had some skepticism towards these whistleblower claims?
Yeah, so the Missouri whistleblower statute has a carve-out, and if you are some type of supervisory, high-level employee, and it's part of your job to report on these things, then you don't get the whistleblower protections that we're accustomed to seeing. So we'll have to see what I don't know the exact job description as the superintendent, but I kind of see it as you're the person in charge, and so it would be within your purview to tell the school board about these types of things. So again, dispositive motion, we'll see what happens, although I will note these being in state court, dispositive motion practice is usually not as successful as it often is in federal court because judges are reluctant to take away someone's right to have their day in court.
In state court, they'd prefer to give them that chance.
Yes.
Okay. So I mentioned that this could result in fat legal bills. And I've got what I would consider a good example here. There's a long simmering case in St. Louis County. This is supposedly going to finally go to trial this summer. Troy Doyle sued the county after he was passed over for police chief. Had some pretty damning allegations there. My colleague at St. Louis Magazine reported that the county's legal bills have already risen to more than $900,000. That's without the case even going to trial. That seems shocking to me. Dave, do you join me in my shock?
No, not really. So one of the things that I frequently tell people is that litigation is really, really expensive, especially when the stakes are high. And what we have seen with a number of these lawsuits involving failures to promote or dismissals or things like that is that juries are willing to hand out very, very hefty verdicts. And so that raises the stakes. It makes it more important for the municipalities or whatever government entities to secure really high quality representation, and that comes at a cost. And so I think that that's what we're seeing here. Now, I understand it'll make people's eyes water to see $800,000, $900,000 in legal bills even before you get to trial. But I mean, that's the industry's standard these days. I would say I'll toss it to the others to see if they agree or disagree.
Yeah, does that feel like the industry standard, $900K to get to trial?
I didn't bat an eye at that. Now, granted, this is taxpayer money,
Sure.
so there's a different level of appreciation.
Easy not to bat an eye. Someone else is writing the check.
Right. But no, I mean, litigation in our country, whether it's state or federal, very, very expensive. I tell clients getting to trial, you're actually potentially losing the litigation because now you are no longer in control of that case, especially if it's a jury case. And so, this talk of can anyone sue and things like that, if you can fund it and you can, again, a meritorious or at least a good faith case. I mean, shocking to maybe some of our listeners, there are ethical obligations before we bring suits, right? That has to have a good faith basis. But if you bring a suit and you can fund it, the finances really yield toward a settlement because neither party can really take it all the way to trial and have a decision which could go either way depending on what a jury hears or doesn't hear or what catches their collective ears. So, and the trial itself is easily going to be well over six, probably could be seven figures. So we're just talking about the trial.
Wow.
Yeah.
The trial itself, you think we're talking at least $1 million?
It could be easily, especially if there's experts and things like that.
Jenny, I see you nodding.
Yeah, that was going to be my comment. If you think $900,000 is a lot, just wait till they prep and go to trial, and that bill is going to be, probably doubled, I would think.
And the thing about the American system is that if the county wins at trial, they still have to pay their own legal bills, right? It's not this like, oh, well, you shouldn't have brought this lawsuit. I guess you have to pay for my lawyers.
So, yes, that is generally the answer. This being an employment suit, there are provisions, especially on the plaintiff's side, who prevail in an employment lawsuit, that they are entitled to their attorney's fees. And that's sometimes why you see these employment cases being so expensive, because a lot of times the attorney's fees on that side are going to far exceed what the person's actual damages are.
But it works great for the attorney to take that case.
Exactly. It works great for the attorney. And if you want to, get an insight into what some of these fees are, you can look at when they're submitted after the end of the case to see what's being claimed. On the defendant's side, while there is a mechanism that a defendant can ask for their fees back, it's rarely successful. They really have to show almost some type of bad faith, frivolous filing to get their fees.
Dave? Sorry, you were hoping to jump in earlier, and I wanted to get to you.
So what I wanted to point out is there's a reason that the NFL settled the Rams case. Because
and it's not necessarily that the city was an innocent victim. No.
Yeah, but because when you go to trial, you are rolling the dice. And agreeing to settle, agreeing to pay a certain amount of money is basically a calculated choice, because you are recognizing the risk that you run if you go ahead and go through the process. Not just the cost of your legal representation, but the risk of a major verdict against your client. And so there are significant pressures for, I think, both sides to settle, so that you have a level of certainty about what the outcome is, as opposed to putting it out there and letting the jury decide what the outcome is going to be.
Yeah. I do want to note one thing in favor of the attorneys who are handling this case for the county. This case has had so many twists and turns, and that's one reason I think the bill has grown over time. One twist that was just fascinating to me, apparently this case was set for trial last May. It was going to go to trial on like a Monday. Well, on Friday, the terrible tornado that ripped through North City did serious damage to the office of Troy Doyle's attorney, Jerome Wooten. It's like, that's a good reason to push back a trial. I'm wondering, just from the experience of our panelists, once something has been set for trial, everybody's moving towards it, we're getting a few weeks out. What does it take to get a trial canceled? If I'm saying, I've been summoned in, I have to get a colonoscopy, is that enough to push that back?
Depends on your judge. And and depends on a lot of opposing counsel if they're going to fight you on it.
So if you can form an agreement, if everybody wants to push back, that's a little easier?
That's a little easier, but it's not a guarantee. And judges do sometimes get frustrated with attorneys when they are asking for continuance after continuance. And I've, had it where both parties are like, we're really not ready. We can't do this date, and it's, too bad.
Arindam, have you seen that happen?
Yeah, absolutely. I mean, if you can get an agreement, a judge is more likely to at least consider it. But judges are people too, and they have really tight dockets, especially in federal court. And if they have a week or whatever, so many days set for that trial, he or she will say, that is your time, or really force, mediation or something to create some sort of resolution. Anything that can clear up that docket for that judge or stick to that timeline is critical, because there's so much that a judge has to manage, and the judge's staff, of course.
Dave?
Yeah, the one thing that I'd add to that is a lot of lay people don't necessarily realize that sometimes judges will double or triple stack trial settings, because there's a recognition that a case may settle, therefore trial is no longer necessary, so this other case gets bumped up, and all right, it's going to go on this particular week. But that is something that does occasionally happen, where you've got a trial scheduled for one group, and then that case resolves, and so, okay, next party up.
You're ready to go.
Yeah, you better be.
And can you tell, looking at the judge's schedule, you're like, well, one of us is going to have to go, but I think maybe they'll get stuck with this date. I won't be prepared.
I don't think I've ever seen someone not be prepared. Like you got to be prepared.
I've definitely made the call to the case ahead of me, be like, so are you guys really going? Is this really going to happen? Are you going to settle? And is it going to be my turn? Am I ruining my weekend or not?
Yeah, that's a great question. We're talking today to our Legal Roundtable. That is Jenny Woulfe, who's an attorney with the Clayton firm Galloway. We're also joined by Arindam Carr of Polsinelli and Dave Roland of the Freedom Center of Missouri. Coming up next, the woke ginger files suit. This is St. Louis on the Air on St. Louis Public Radio.
Hi, I'm Laura Hamden, and my colleague Jessica Rogan and I are your daily hosts of the Gateway newsletter. We meet with the editors in the STLPR newsroom every weekday to bring you the top local stories of the day in a quick and easy 6-minute read by 6 a.m. In an age of overwhelm, it's a refreshing, thoughtful take on the news day, if we do say so ourselves. Fine-tune your daily news habit with the Gateway newsletter. Subscribe at stlpr.org/gateway.
Welcome back. I'm Sarah Fensky. I'm here with our Legal Roundtable. We are having a great discussion today, just a terrific panel. That includes Arindam Carr, who's a shareholder at Polsinelli, also joined by Jenny Woulfe, who's with the Clayton law firm Galloway, Johnson, Tompkins, Burr, and Smith, also president of the Lawyers Association of St. Louis, and Dave Roland, senior legal advisor for the Freedom Center of Missouri. So we've got a good one to chew on here. This was a very high-profile case, ended up making international news. The British papers all over it. Justin Krailman was fired from his job at Food Outreach, Inc. this year. His lawsuit says it wasn't because of anything he did at work, but rather his side hustle. He's an influencer on TikTok and Instagram. He frequently posts about politics as the woke ginger. His lawsuit says he was fired after posting about Enterprise's business associations with Immigration and Customs Enforcement, and an Enterprise bigwig is on the board at Food Outreach, Inc. So the fascinating thing about this case, Justin Krailman is suing under what I would call a very obscure Missouri law that apparently prohibits Missouri employers from terminating people for their political beliefs. Arindam, did you even know we had a law like that?
No.
I didn't either. Okay.
No.
Two of us.
Yeah.
So here he's got this lawsuit. Do you think he has any chance of succeeding?
Also no. Listen, it's a creative lawsuit, but I think we're talking about mountains of precedent here, and the way the termination happened, the basis for the termination, I don't see a lot of teeth in the case in terms of being meritorious. I just don't see it.
So, Jenny, the one thing that I hear from every lawyer that I've asked about this case is they will go look up this law and they'll say, well, yeah, that law is technically on the books. If that law is technically on the books, why is no one using it?
You know, I did that exact same thing. It's a good question. The little bit I could see it being used is in a couple cases having to do with bans on campaign contributions. And they did say, you can't, under the law, ban people from, as an employer, you can't say you can't, donate to a political cause. But this case is different. It's not his political beliefs, it's his statements and how he acted on them, which got him in trouble. And yeah, I'd have to agree with Arindam that I don't see it going far.
Yeah, I mean, here's a guy with a large platform, and he's also involved in the development department. And here's a company that you might want to contribute to your company. You can see how it's more than just a political belief. It's actually affecting his job.
Yeah, correct. Also, of course, assuming all of that is true, which Enterprise and Food Outreach denies.
Yes, and that is, I appreciate you making that point. Dave, you're a guy who loves free speech. I understand this is different. It's not the government firing this guy, but what do you make of this Missouri law and why it doesn't appear to have any teeth whatsoever, or maybe not relevance?
So it's a very interesting statute. I think when I read the statute, what it's really focused on is advocating for specific candidates or political parties or ballot issues. I think that when it talks about political beliefs, that seems to me to be what the statute is aiming at, as opposed to just kind of a general perspective. Hey, this company is funding, or they're engaged in public affairs in some way that I think is suspect. And that's really what the issue was, is he said, Enterprise is renting cars to ICE, and he didn't like that. Well, that's not really taking a stance on any particular politician or party or election. And so I'm not sure that it would fall within the scope of this statute to begin with. But then you've got the question of, is the statute even constitutional if they're going to try and apply it this way? Because the fact of the matter is that businesses have First Amendment rights as well. And to require a business to associate with somebody who is actively speaking against the company or advocating against the company's interests in some way, that raises First Amendment questions of its own. So I'm skeptical whether this law could be constitutionally applied, even if his behavior fell within its protections.
So let me give you a hypothetical. I know you guys love it when I spring hypotheticals on you. Let's say I work for a very straight-laced employer that strongly believes in capitalism, and I wrote a giant check to a socialist, say I just love the new mayor of New York City. Could they fire me for that, do you think, in Missouri?
I don't think so. No, under the statute, they absolutely could not.
Okay.
So one of the provisions of this statute is that they can't take retaliatory action against somebody for making a contribution to a political figure or a political party. And in the same way, they also can't coerce someone to make a contribution to a political figure or political party that the business likes. And that, I think, might well be enforceable. But it's different when we're talking about pure speech. When we're talking about somebody, especially if they are speaking in a way that is directly adverse to the company's interests, although it's not really clear to me exactly how criticizing Enterprise impacts this food company that he was working for. Clearly, Enterprise had some influence over the people who ran this company, but it's not clear to me what that connection was.
And we do want to make clear again that Enterprise denies having anything to do with this or influence. I think they had donated quite a bit to this nonprofit. Arindam?
Yeah, and that's what I was getting at. I think from the nonprofit's point of view, and let's just put aside whether this speech put into jeopardy its 501c3 status. Let's put that issue aside. A nonprofit and trying to operate, and especially in this day and age, being able to secure funding and maintain its viability and sustainability to deliver on its mission. I do think it's a little different than a for-profit entity in that they have to be very cognizant of what employees or even volunteers are doing, and does that impact the reputation of the nonprofit, not only in terms of its delivery of its mission, but its ability to secure funding to deliver on that mission. So I do think there's some very real practical aspects here that have to be considered here, even putting aside some of the legal arguments here.
I was interested that his employer seemed very supportive of his side job as being this influencer. It was only when it hit really close to home that it became a problem. And I guess when you see that, you start to understand why so many employers are not cool with somebody having a side job. And they're saying, no, we actually don't want our development director to be out there wading into national politics on TikTok. It can be a can of worms, I think, for nonprofits.
Absolutely.
So Bayer is in the news again. Isn't Bayer always in the news? Roughly 200,000 people have sued this company, claiming that its weed killer Roundup, developed here in St. Louis by Monsanto, caused their cancer. Well, in February, a New Jersey lawyer announced he'd reached a $7.5 billion settlement. Through it, each person suing could see at least $48,000 if they opted in. Now, that's not much compared to what people are winning at trial, but it's also a guaranteed payday there. Well, yesterday, the Supreme Court heard Bayer's appeal in a case that could dramatically limit Bayer's liability over Roundup. That decision will likely come down in late June or July. People suing in have to opt in by June 4th. So this is a big question for people right now. Do you take the $48,000 or do you just say, to heck with it, I'm going to try to do this? Jenny, what would you advise a client to do?
It's how much you want to gamble here and what kind of stomach you have for it. I know, and I think Arindam's going to talk about because he listened to the oral arguments, but what I've read about them so Bayer's claiming that the state law claims are preempted because under EPA regs that it did not have to contain the warnings that they said they didn't have. And it sounded like some of the justices, and this is a conservative court, and the Trump administration has thrown their support behind Bayer. So there's a fair risk that if the if the court sides with Bayer, then your suit is gone and you get nothing. And it is rough for these people because they have to decide on this class action whether or not to go for it before they're going to know the answer to that question. Another consideration, though, is we were talking a little bit earlier about how expensive lawsuits are. And for those that are not in this class action settlement, to bring these suits against Bayer, not just any firm, you have to have a lot of resources. So even finding representation, I'm sure they'll still be out there, but that will also become more difficult.
Do you think you'll see lawyers go, you should take this settlement? I'm not sure I want to soldier on in light of some of these circumstances. Arindam, you sat through these arguments yesterday. What kind of vibes are you picking up from the nation's highest court?
Yeah, it was a very, very good oral argument. For any young lawyers listening, take a listen to it. Paul Clement was representing Bayer. He is sort of the epitome of Supreme Court appellate advocacy, really, really good. The other side also had a Scalia clerk who was arguing for them, and just really, really good high-level discussion. The actual issue, I think, for lawyers is fascinating, which is this preemption issue. We're talking about the Federal Pesticide Act and whether there's an express preemption. But it does have real
preemption saying states can't do their own thing.
Federal law controls, and that's really the crux of the issue here, that under federal law, Bayer complied with the labeling requirements, and this case is about whether a state jury can say, no, this label should have gone further. It should have said, had a cancer warning. And so what the Supreme Court is struggling with, or at least figuring out, is whether there is this preemption, i.e. if a company complies and properly meets all the requirements for its labeling requirements, including re-registering and meeting those labeling requirements, are they still subject to liability if a jury in this state, in this case Missouri, or a jury in another state comes up with a different decision saying the label should be different? So from a commercial standpoint, does a company have to have potentially at least 50 different labels? Or, depending, if you go down to the jury, every case that comes up, a different label based on what that decision is? Or do you have uniformity in just this one label that requires, as required by the federal government? And so it is fascinating on that front. It's also really fascinating, as Jenny was mentioning, in this political climate. This is the same court that has been really against the idea of giving a lot of leeway to federal agencies in terms of regulatory. The old Chevron case, the Loper-Bright decision, which really kind of reined in on sort of the freedom of agencies to opine on what regulations may mean in the absence of clear authority from Congress. And so you heard the counsel for the class really to say, listen, this is sort of the same thing. Are you really going to trust the EPA to do this? And so
it sounds like some justices were like, yeah, good question.
Good question,
do we
right?
want to trust the EPA?
Absolutely. So there is this very interesting sort of mix of, counsel really leaning in on sort of the text controls here, and which is a very classic conservative position, versus this, are you really going to let the EPA kind of control this? Shouldn't this go to the states? So it will be interesting what comes down. I do think that Bayer will prevail in this case, but that's my opinion.
I like it when people make predictions. I can hold them to it. Dave, we have about 90 seconds left. What's your take on this?
I think the curveball here is that Missouri had passed a law that allowed for these kinds of suits. And I think that generally speaking, courts have required the federal government to be more explicit when they are preempting an area. So, for example, in the area of firearms lawsuits, Congress came out and they said you cannot sue a firearms company for injuries caused by the use of their products. Congress didn't do that here. And so I think that there is room for a ruling against Bayer. I don't know that I would bet any money on that.
Would you bet $48,000 on that? This is the question before people with lymphoma.
If I'm the person whose money is at risk, I would not be betting on it. I would probably take whatever bird is in the hand. But I think that there's a decent chance, if not a likelihood, that Bayer is going to lose this particular suit.
Wow. We have a split among our panel here.
Have us
Jenny?
come back.
That's right. After June.
In just our final 10 seconds here, are you thinking Bayer can win like Arindam thinks, or do you think this is a loss for Bayer?
I'm probably putting my money on I think Bayer can win, but I do think there's room for argument, and it's not the only preemption case they've heard this session. So it'll be interesting to see if they are consistent on those or not.
We're going to have to bring this whole panel back in so that people will have to stand up to their predictions here. Jenny Woulfe of Galloway, Johnson, Tompkins, Burr, and Smith, thanks so much for joining us.
Yeah, I had fun.
And Arindam Kaur of Polsinelli, thank you.
Thank you.
And Dave Roland of the Freedom Center of Missouri, thank you.
Always a pleasure, Sarah.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.